Hello and welcome to a special interview for the Wire.in. Friday's press conference when four of the most senior judges of the Supreme Court revealed for the first time in public a private letter they've written to the Chief Justice of India complaining about how he handles administration of the top court has hit India's judiciary like a veritable earthquake. Literally nothing like this has ever happened before. With me to discuss the development, its implications and repercussions is India's former Law Minister, Ashwani Kumar. Mr. Kumar, let's start with yesterday's press conference when, as I said, four of the top judges of the Supreme Court revealed for the first time in public a private letter they had written some 2 months earlier to the Chief Justice, complaining about how he handles administration and in particular the listing of cases in the Supreme Court. How do you, as a former law minister, respond to this development?
First of all, Karan, this is unprecedented. This is exceptional. But I think the most important thing that we must ask ourselves is, what compelled the four distinguished senior-most judges to go public with their letter? They have stated it in their own words that their entreaties and their appeals to the Chief Justice in person as late as the morning of the day on which they disclosed this letter had gone unheeded. And they went to the extent of saying, and if I'm not wrong, Justice Chalameshwar said that we did not want posterity to say that we bartered our souls and did not disclose in public domain what needed to be said in the larger interest of the nation.
So they were pushed into this measure.
It is quite clear, and that has been revealed from the letter itself, unless one accuses the four judges of saying something which is not untrue and which is not true and which I will never say.
In other words, they were effectively, metaphorically driven to the wall. This was the last resort left to them. So with reluctance, they had to go public because there was no other option left.
That's right. And they said in so many words that it is with deep anguish and pain that we are holding this press conference.
I'll come to the causes why they chose to speak out in a moment's time, because their letter that they released, as well as their comments at the press conference, made their reasons pretty explicit. But first, let me put this to you. Some people have characterized what happened yesterday at the press conference as a revolt. Others have called it a rebellion. Perhaps many more have said that this is a clear sign of a deep and very sharp divide at the very top of India's judiciary. Do you accept any of those three characterizations?
I think the last. There's no doubt there is a deep divide. And we who practice in this court have been sensing it, have been feeling it, and we've been witnessing this on a daily basis. So this comes as no surprise to us. What, however, has come as a surprise to us was the holding of a press conference. So as I said earlier, I would, personally speaking, and speaking for myself both as a lawyer and as a citizen, and who has had the opportunity of knowing the work of these judges and knowing them for their rectitude and probity, would want to give them the benefit of doubt and would sympathize with them, because I think they left no one in doubt that they were compelled to take this step as a matter of last resort.
Let me pick up on the first part of your answer, and I'll come to the second part in a moment's time. This is something that you yourself had sensed as a practicing lawyer as a problem that was simmering and festering, so you're not surprised it boiled over in this way. In other words, people like you who know the Supreme Court fairly closely were aware that there were deep-seated problems.
And not only me, many senior counsel, many lawyers who regularly practice in the court were aware of certain things which were discordant, which did not resonate well either with the members of the bar or with members of the highest judiciary itself. And as you've seen, that there are many judges who have openly said that things were not right, and some have not so openly said, but they believe that things are not right in the Supreme Court.
So this was a development waiting to happen.
Development waiting to happen, but I had not thought that the four judges would hold a press conference. But the fact that they were compelled to hold a press conference must tell us something about the anguish and the malaise and the extent of the malaise that had stepped.
Let's come to this fact that they actually chose to hold a press conference, something that is absolutely unprecedented. Justice Chalameshwar himself described it as an extraordinary event. Now, Justice R.S. Sodhi, a former judge of the Supreme Court, has publicly criticized the four justices for holding this press conference. He says it was unwarranted, almost suggesting it was unforgivable. On the other hand, Kapil Sibal, a fellow former law minister like yourself and a colleague of yours in Congress has actually, in the Indian Express, complimented the judges for their courage and conviction. Where do you stand on this issue of holding a press conference? Were they justified to do so, or have they blundered badly?
I don't think they've blundered. I think they've departed from convention, but extraordinary circumstances call for extraordinary actions. And I think that when the judges themselves have given justification of overarching national interest and have invoked their conscience in support of what they did, I think that is where the matter should rest.
Let's then come to the reasons which impelled them, in a sense, to take this extraordinary step. The Justice Chelameshwar, in the comments that he had to make before they released the letter, said that they were acting because, and I'm quoting, the administration of the Supreme Court is not in order. The letter itself, when it was made public, revealed that two cardinal rules were no longer being observed. As the letter says, and I'm once again quoting, first, well-established conventions that should determine the listing of cases are not being observed. And secondly, some judges are arrogating to themselves matters that should be heard by appropriate benches. Now, you're a former law minister, you're a practicing senior lawyer, you understand and follow what's happening at the Supreme Court. Are these two cardinal rules being flouted? Or is this a bit of an exaggeration, as spokesmen for the Chief Justice have said to the papers today?
Well, let me put the matter in perspective. There is absolutely no doubt in my mind about the fact that as per the law established, as per the conventions which have been followed since the establishment of the court, the Chief Justice for matters of administrative convenience is the master of the roster. There is no denying that fact. But it is,
and to be honest, these four judges don't deny that either.
Yes, nobody does. Nobody has ever denied that. But it is equally true, and which is not being stated loudly, that established conventions relating to the exercise of this power tell us that the assignment is done on the basis of certain well-established norms. A, that you normally do not remove from the benches presided over by judges who have earlier held a particular matter. And B, considering the complexity and the delicacy of the matter, normally senior-most judges are assigned very important cases.
Are you suggesting that all three norms were breached by the present Chief Justice?
Well, the general perception is that there has been a departure from norms. Now, maybe the Honorable Chief Justice has a justification, and since he has not spoken, people do not know the other side of the story.
But in the absence of any justification, which additionally has to be convincing, it does look and seem, at least to these four judges, that he's breached these norms. That A, the norms that should apply when cases are listed were not applying. B, cases were being taken away from judges who'd earlier adjudicated them. And C, senior-most judges were not getting the most important cases, they were going to junior judges instead.
So if the four senior-most judges have themselves in their letters so stated, I think there is no further scope of argument. Who would know the conventions of the court better than these four judges, one of whom is going to be the next Chief Justice of India?
Ranjan Gogoi.
Yes.
In which case, put this in perspective for me as a law minister. If it is the case, and I only use the word figuratively, not questioningly, if it is the case that these cardinal rules are not being observed, how serious a lapse is it? How serious a problem is it?
It detracts from the sanctity of established procedures. And remember, in the administration of justice, procedural proprieties are critically important.
Justice Chelameshwar, in his spoken comments, said that this could even threaten India's democracy. Would you go that far?
Well, since they have correlated this to a threat to the independence of judiciary, and independence of judiciary along with democracy are parts of the basic structure of the Constitution, you could perhaps link the two, because certainly it would impact the functioning of our constitutional democracy, in which the Supreme Court occupies an extremely important position.
Now, expanding on what has been said by the four justices themselves at their press conference, one of your colleagues, a senior Supreme Court lawyer, Prashant Bhushan, yesterday said on television that the Chief Justice was making a practice of allocating important cases to benches where relatively junior judges sit. And he added that he was doing so because he believed these judges would deliver the sort of verdict or judgment that the Chief Justice wanted. And in other words, what Prashant Bhushan was saying is that the Chief Justice was trying to predetermine the outcome to suit his preferences. Is that a concern that many people like you share?
That's the inference that people are deriving, but I would not go that far. I think it would be unfair of me, in the absence of any personal knowledge to that effect, to ascribe motives. But the fact that certain conventions have been departed, a very strong inference is being raised, and it has not been put to rest. So somebody must put this to rest.
You're saying two very important things. You may not endorse the inference, but you're accepting this is a logical inference to raise. And secondly, because that inference hasn't been addressed, it hasn't been put to rest, and so it remains an inference that needs to be addressed.
All I'm saying is that this is an inference that needs to be put to rest, and I think somebody must come and disprove this inference. It is critically important for the health of the highest judiciary.
In other words, and let's be blunt about it, there are question marks that this inference raises about the behavior of the Chief Justice, and for the interest of the judiciary and our democracy, it's critical that this be put to rest. These question marks be put to rest.
The 4 judges have stated so plainly. I don't think I need to add anything to it. And who would know the functionings of the Supreme Court better than these 4 judges?
Which is absolutely true, because they are in order of seniority immediately after the Chief Justice. We're talking of the 2nd, 3rd, 4th and 5th most senior judge of the Supreme Court. There are 2 corollaries that in a sense flow out of the inference we're just discussing. The first is that the Chief Justice is in some sense beholden to the executive of the day, the Modi government, and that in some sense he is acting to further its interests rather than acting impartially. That is a corollary that flows out from it, doesn't it?
I wouldn't like to comment on that one way or the other. I think the office of the Chief Justice of India is far too important for someone to impose one's own personal inferences as a matter of argument in a public debate. I would not like to go to that extent.
I can understand your reluctance because you speak as a former law minister, not just as an ordinary citizen. But there is a second inference that also, a second corollary that also flows out of this inference which we are discussing, and that is the belief that junior judges are somehow pliable and willing to do the Chief Justice's bidding, which is why he keeps giving relatively senior cases and important cases to relatively junior judges. That is another corollary that flows out of this.
Now, endorsing that inference on my part would amount to casting aspersions on the independence of the judges, which I would not like to do at all.
Again, I can understand your reluctance, but logically speaking, would you accept that these are 2 corollaries that flow out of that central inference?
I would say that if conventions had been established that senior-most judges are normally assigned important cases, there must be a logic or a reason to it. And if there isn't, then serious questions arise. But to extend the logic to say that these assignments are necessarily made with a view to achieving a particular judicial result would, I think, be going too far on my part in the absence of any personal knowledge.
Absolutely, and the operative word in that sentence is necessarily made. Let's come to something else that the 4 judges at their press conference revealed. They made it clear that although the trigger for the actual date on which they chose to have the press conference could have been an event that morning itself, possibly, as some people believe, the assignment of the lawyer case to a relatively junior bench. But they added that their list of grievances went back considerably in time. For instance, the letter that they released was at least 2 months old. The Hindu claims, in fact, it's 3 months old. It's dated October 2017. This suggests 2 things, does it not? One, that they have a long list of grievances. It's not a one-off event. And secondly, they've been trying to get the Chief Justice to see things in their light, and they failed. In other words, they've been repeatedly rebuffed by the Chief Justice. So they have a long festering problem and a certain history of being rebuffed by the Chief Justice.
That seems to be a reasonable, not only an inference, that's the obvious corollary or consequence of what happened.
Which means that the problem that you were aware of, and many other lawyers you say are aware of as well, is a fairly long-standing problem. It's been simmering, and it's only understandable that the pot would come to boil at this point of time.
That's right.
Has the Chief Justice, therefore, because to most people this would seem like an obvious question, has the Chief Justice mishandled this situation?
Seems to be so.
Is this a resigning matter?
Depends on the discretion of the judge.
When you say the discretion of the judge, do you mean the discretion of the Chief Justice himself?
Yes.
In other words, you're saying
His position has been made untenable.
his position has been made untenable.
Yes.
Well, if a man's...
Unless he rebuts it.
And so far he's chosen silence instead. I mean, over 24 hours have passed and he's silent.
There is no doubt in my mind that the prestige of the office of the Chief Justice of India and the position of the Chief Justice of India has been made very, very precarious and untenable.
If the position is made untenable and his response is silence, does prolonged silence make it more untenable?
Well, only time will tell.
If a man's position is untenable, can he continue in that position?
As I said, these are matters best left to the subjective discretion of the person concerned.
Let me ask the question a little differently. You've been law minister. If you had been Chief Justice and the 4 next most senior judges had gone public, revealing a letter they'd privately written complaining about your administration of the Supreme Court, virtually accusing you of choosing benches for preferential reasons, not rational reasons, would you have continued as Chief Justice, or would you have felt morally incumbent to resign?
Let me answer this extremely pertinent question, and I have to answer it in the way I must. I have been of the firm belief and conviction that there can never be a trial by accusation. Guilt of any kind, either in matters of propriety or in matters of culpability, can never be fixed merely by an accusation. But in this particular case, the insinuation and suggestion comes from the 4 senior most Supreme Court judges who carry the weight of moral authority behind what they say.
One of whom will be
the Chief Justice of India, and who are colleagues of the present Chief Justice, who are not necessarily in an adversarial position to the Chief Justice, or who have not been accused of, all of 4 of them cannot be accused of any personal animus or motivation against the Chief Justice. In that situation, what I would have done, I do not know if I were in that position, but I would certainly concede that my position would become morally very, very untenable.
You're saying that even though you can't guarantee if you were in that position you would have resigned,
depending on what would have happened.
But you would have felt a moral compunction to resign.
I would have felt morally weakened in the discharge of my functions.
Is the present incumbent Chief Justice now morally weakened in the discharge of his functions?
It is for him to say whether he considers himself to be so weakened or not. I don't know.
But in the eyes
he held court. He did all his work, and I think one can't find fault with that.
But in the eyes of the public, surely he is morally weakened as Chief Justice?
Well, I've said on record that the institutional integrity of the Supreme Court has been destroyed. The institutional integrity of the Supreme Court and the standing of the highest court in the country as the ultimate moral arbiter of the nation has been compromised.
Let me ask you one more question about the Chief Justice's silence. Over 24 hours have passed. We're recording this interview on Saturday at about 5 in the evening. More than 24 hours have passed and the Chief Justice is silent. How long can he continue to afford to be silent before his silence itself begins to damn him?
Well, sometimes, as you know, in Roman law it is said that silence could be consent, and sometimes silent is the best way not to expand the controversy. So I don't know which way this will work out. But quite clearly the matter is now in public domain. It will be debated. I don't think you can gag political parties or people from raising these issues. This country needs an independent Supreme Court. It needs an independent judiciary, which is a part of the basic structure of the Constitution. And all stakeholders must collectively cooperate and come together in order to restore to the Supreme Court its prestige.
Let's at this point come to the lawyer case, because it's believed that the assignment of the lawyer case on Friday morning to a relatively junior bench headed by Justice Arun Mishra perhaps was the trigger that sparked off the press conference. That is a widely held belief. Prashant Bhushan, and I'm quoting him because he's given me permission in this instance to do so, has both tweeted and said on television that he believes Justice Arun Mishra is needlessly and uncomfortably close to the government of the day. He says that leaders of the government have visited his home for the wedding of his nephew. Now this case, the lawyer case, was brought as a petition by Prashant Bhushan and handed not to a senior judge but to Arun Mishra. Are you uncomfortable by the fact that the lawyer case in particular, with its obvious connections to people in the BJP, has been handed to Arun Mishra, who's supposed to have connections to the BJP?
Well, some people are uncomfortable with this, but I wouldn't like to go to the extent to which my other colleague has gone, and merely because somebody has attended somebody's wedding doesn't make the judge complicit. I would reject that charge. I think we all have many people who come to our weddings and social functions, and I think that has been India's tradition, and I would not like to link the two. However, having said that, people do believe that certain people, including members of the judiciary, have certain political preferences, and I think as citizens they are entitled to have those preferences, but whether those preferences would impact the judicial work or not, only concrete fact situations can be appointed to that.
Let's leave Prashant Bhushan and everything he said out of the question and out of the picture. Let me ask you a direct question about Arun Mishra. Do you share the concerns that some lawyers have? And I won't embarrass you by naming those lawyers, but do you share the concerns some lawyers have about Justice Arun Mishra? His behavior and the cases he's getting?
It has been my policy in politics and in the profession never to comment on individuals.
Let's then pull back, not talk about an individual, and let me ask you, what do you believe are the repercussions for the judiciary as a whole, for the Supreme Court in particular, of Friday's press conference and the fact that this letter, with its fairly substantial complaints about the Chief Justice's handling of administration, has now become public property?
As I said, the institutional integrity of the court has been dented. Its moral superiority as the arbiter of the Constitution's conscience is negatively impacted. It will take us several years to restore the prestige back to the court. And
you mean several years?
Yes. This doubt that has been created about the highest judicial institution in this country is a very sad thing to have happened.
So serious damage has been done to the judiciary right at the very top?
Absolutely.
And it will take several years to rectify?
In my opinion, yes.
What about the collegium? The collegium comprises 5 judges, the Chief Justice, who's now all on his own on one side, and the other 4 judges who are on their own but together on the other side. And I'm sorry to use the word sides when you talk about the judiciary, but clearly the collegium is split in 2.
It is.
Can it function effectively hereafter?
I don't think it is functioning effectively.
I mean, it hasn't been functioning effectively, so the question about functioning effectively in the future simply doesn't arise.
That's what the general impression is. I'm told that the meetings of the collegium have not been held as often as they ought to have been, and there are sharp differences. And mind you, this is hearsay, but very prominently so stated in the corridors of the Supreme Court.
In fact, Justice Chelameshwar himself had opted out of those meetings because he believed that decisions ought to be made public and reasons ought to be given, which other judges dissented from.
See, what makes this an extraordinary case is not just the difference of opinion on one matter or on one issue. 4 senior-most judges have had a litany of complaints in the administration of justice, which impinges on the functioning of the court, even on the judicial side. That's the inference. It is not purely administrative in the sense of assignment of cases, but as you asked me, was it intended to achieve a particular result? Now that may be entirely misplaced conjecture, but the fact is that somehow this impression is gaining ground, which is not good. So if this is not a true impression, it is incumbent to dispel this.
In the meantime, if the collegium is not functioning properly, and I presume after this public development of Friday, its ability to function harmoniously will be considerably weakened, how do we appoint new judges? The collegium is the institution that does it. How now will that happen?
Unless the Chief Justice of India reaches out to his colleagues and finds a solution, there's a problem. But it is not something that is completely undoable.
What so far, and we are talking about Saturday at 5 o'clock, the Chief Justice hasn't reached out. What happens if he doesn't reach out?
Well, I think it's very, very sad situation for the court and for the country. I mean, how can the highest court at the very apex be seen to be so divided amongst itself that people of India will lose faith in its ability to discharge its functions, whether it is in the matter of appointment of judges, or in the matter of dispensing of justice, or in the matter of supervising the administration of justice in the country as a whole. Remember, the Supreme Court actually supervises the administration of justice in the high courts of the country. It's an extraordinary situation. I had never imagined that in my lifetime I would see 4 senior-most judges have a press conference against the Chief Justice of India.
And yet it's happened.
It's happened.
But now, the initiative to repair the damage, you're saying, lies with the Chief Justice.
The head of the institution always has the duty to reach out.
Yeah, and yet the head of the institution is not just silent, he hasn't even spoken up in his own defense. Well, but in addition, so far, he's not taking any step to take an initiative.
But let's give him the benefit of doubt. It's only happened yesterday. Maybe he's reflecting over it. Maybe he's consulting his
Maybe he's in shock.
Maybe he's consulting his other brother judges. Maybe he's consulting people he needs to consult. But it's
how
just 24
long can
hours.
we wait before perhaps you feel someone else, maybe a Fali Nariman, maybe a former Chief Justice like Venkatachalaya, or maybe a former Chief Justice like Thakur, need to step in and, to speak figuratively, knock heads together?
I don't think that should be necessary. I think the Chief Justice of India
should be necessary, but is there a chance it might become necessary because the Chief Justice doesn't act?
How can I comment on that? Suppose the Chief Justice himself asks somebody else to be the mediator. It is possible.
Would it be wise for him to do that, given that he's become a controversial figure?
Personally speaking, and this is my personal view, I think if at all somebody has to reach out to mend the situation, it is the Chief Justice himself.
So he has to not just take the initiative, the onus is on him to do it himself as well.
Yes.
One last question. Is there a role for the government to play? And I'll tell you why I ask. Not just because you've been law minister, but also because Justice Ganguly, a former justice of the Supreme Court, has publicly said he believes the government must take the initiative.
Well, I wouldn't say that government has no role in the matter. I think the government of the day is equally interested, or should be equally interested, in dispelling the misgivings that have now come in the public domain and that impact the independence of the judiciary, and upholding the Constitution, which includes independence of judiciary as its basic structure, is also the job of the government of the day. And I think the weight of its authority, and whether through the law minister or through any other mechanism, in case, now that is a big caveat, in case it is felt generally that the government can be a helpful facilitator or a mediator, I don't see anything wrong in government playing that part. But from what I read in the papers and hear on the television, government has said this is an internal matter of the judiciary and should be resolved from within. And I think the preferred way is for the Supreme Court to resolve it in-house.
So the government should only consider stepping in after a prolonged period of time if the Supreme Court can't resolve matters internally in-house.
Or if it comes to that judgment, or if the Chief Justice itself requests the government to intervene, which I don't think is necessary or should happen. But there could be a host of circumstances.
If it comes to the government having to intervene, and that won't happen overnight, it could take time before we reach that point, who would be, in your opinion, the suitable person to do it? The Prime Minister, the Law Minister, or should it in fact be someone above the fray of politics like the President?
We've never involved presidents in matters of the state.
So rule him out.
Well, I rule out nothing because the President appoints the Chief Justice at the end of the day. But this has never happened. But since nothing of this kind has ever happened, we don't know which way this will unfold. But to conclude, I think it is entirely within the province of the Chief Justice of India to find a way to resolve it. I don't think the 4 judges, and I may be wrong, but my first impression is I don't think the 4 judges would be unresponsive to a meaningful gesture by the Chief Justice of India.
Which means the ball is squarely in the Chief Justice's court and he needs to act in his own interest, in the interest of the Supreme Court, in the interest of Indian democracy.
In the interest of the institution above all, which he heads. And I also say at the same time that it is hoped that in case the Chief Justice of India takes the initiative, the other judges will suitably respond.
Ashwani Kumar, a pleasure talking to you.
Thank you.